we're asking the consultant to do, which is, are we asking the we're asking the consultant to be at all the meetings, and are we asking them to actually draw a map live when, let's say, someone says, here's my neighborhood, I'd like you to keep it intact. Is the consultant expected to do sort of a live drawing at that meeting, or are we asking them to sort of take that, gather it all together, and then at some point later sort of pull it together for us to consider?
I think if you look on the bottom one, it says producing, digitally storing, projecting on screen for audience viewing, and I think there's an element, as I understood it, is that a good technical consultant would have the ability to have that mapping software there, so the public could see what their input, or see that they could define their neighborhoods. If they say, this an area, they could capture it while they're talking.
No, I have no problem asking the consultant to do that. I'm just wondering what that's going to look like in practice. And again, let's say someone is not too specific about. I think and this is one thing I want to raise for the commission, is make sure we have pretty specific guidelines on what we're asking the public to give us. But let's just say someone comes in and says, "Well, keep the outer Mission District in San Francisco intact." Thank you. I have a certain definition of the outer Mission, but because I grew up there. But when we don't have the level of specificity, where there's some street boundaries or census tracts, whatever we sort of need to actually input into the computer, that's tough for the consultant to figure out then and there. And
Well, maybe I should answer this because I was working with Gil a little bit.
I think Dan has a comment. Let's get that comment.
Oh, and the only reason I wanted to segue in was my understanding early on talking with Karen and the way that it had worked for her in San Diego as well as San Francisco was that when the person came up and said, "I want to keep the outer Mission District intact," and started to walk away, that the line drawer would go, "Wait a minute, so help me up here define what the outer Mission District is, so that we can record this and have your information." So I envisioned, although I've never been to one of the meetings, I envisioned that there was that interplay that the line drawer could have to ensure that they captured the information correctly.
And I think also with the contract with CCP, the benefit of that, is my understanding, is that the technical consultant would work with CCP and they would develop forms and material for the public so that when they come up to give their presentation, they'd have their paperwork or they'd have everything in place so that we could highly utilize any public input.
Yes. And that's fine. I just want to be clear that's what we're going to ask them to do eventually.
And I would add that it's more descriptive than actual drawing, whereas an individual comes up and says, the outer Mission District, that we would project a map, and on that map, then all of us would know what you already know, which is that the outer Mission District. That's kind of that's kind of what we're looking at. So I know if we go down to my neighborhood, that I have an idea of what's up. And certainly by looking at a map, then we would be able to draw on the expertise not only of commissioners but also individuals in the public that might say, no. This is what we're really talking about. So it's a descriptive tool that I think would be very valuable.
And then the other thing, just a point of clarification on is Section 9, where where it talks about meetings and discussions with the commission. And I'm assuming this is not a comprehensive list of everything they might bring up, but I want to make sure that the language gives us the flexibility to say, well, we need a lot of stuff, and it's covered here. And because one of the things, the first bullet is sort of communities of interest, and I don't think that's obviously the only thing they're going to be talking about. We certainly want them to cover that base, but I'd go for more wider language or more general language to make sure the contractor knows and the bidders know that we're expecting a fair amount of information in their presentations to the commission.
What would you add?
Well, I don't know. You can either include a lot of stuff, or you just have some very general language. That's maybe the second bullet, which covers all relevant criteria. That covers all.
Okay. Thank you.
Yeah, because maybe the first bullet just sort of suggests that it's narrower than it should be. That maybe that's the only thing enumerated. Therefore, there's a lot of stuff I don't have to present versus all relevant criteria, which can cover several things. Rather than the alternative, of course, is just to try to bullet everything, which I'd prefer not to do. But if we can just have sort of comprehensive language, I would. give us sufficient, room to.
What if you said something along the lines of an agreed to set of, I know it's going to be hard for them to bid, not knowing what's going to be agreed to, but I guess that's the kind of dilemma you're in.
Well, the first thing I would think is that the people that are going to be the front runners in your contracting are going to know what we're saying here. But I agree that we could open it up to something like present all relative findings and related maps or something like that. And this could, such as community, we might just give it as an example rather than making it the primary heading.
Yeah.
That's fine.
I think that addresses it. Peter. No.
When we draw up the contract, after the contract has been awarded, will there be a definitive statement of work document associated with that? So it can go in at that point in time as compared to be going into this document.
Well, you're not going to want to include, what, the requirements in this document are going to be what is in that contract. Yeah. Okay. It's very defined. You don't, we don't make an award and then decide we want to throw in some other.
No. The statement of work has to be agreed upon by both sides. But usually it's, my experience is that it usually is a lot more detailed than the bidding document.
This is going to be the statement of work in the contract. There isn't another level of detail. If we develop another level of detail, it needs to be in this bid document. Because they're pricing. We've got requirements, and they're going to price providing and meeting those requirements. So everything we want has to be in this bid document so that they can price it.
All right, so you're saying that the bid document, by definition, is the statement of work, and there's no other document that spells out exactly what is.
There will be a contract that results after an award is made. The award will be a standard agreement. That standard agreement will include what we have asked them to bid on and provide a price for. So they should be a mirror of each other.
Yes, they should be, right. Okay. Thank you.
Yeah, I'd like to briefly return back to the conflicts policy statement, and particularly the last line where it says, the very last sentence, where it says, while also assuring the impartiality of staff and consultants. Now, specifically, and I don't know if this question is directed to you, Mrs. Umfleet, or you, Mr. Miller, but I'll throw it out there, and it's a suggestion, not a, it's just a question out of curiosity. In the selection process of the contract, or consultants rather, do we have the capability of considering a clause or an option in terms of neutrality of having that, let's say we find one highly qualified consultant that we all agree upon, and that consultant may be perceived as being overly Democratic or overly Republican. And public perception means a lot, as we all know, with this mission we're on. Can we insert a rider or a clause or a statement or a request that that consultant also include personnel on staff of the other party? Is that something that's consideration? Is that something that we want to keep away from? We want to respond to the public's concern the best we possibly can in terms of being nonpartisan and neutral throughout this process. So how do we fix that or address that issue?
I'll take a crack at it.
Okay.
First of all, the purpose of this is to give you the clear discretion to choose that contractor, even if they've had some partisan relationship in the past, because you think the totality of their experience and their ability to be impartial makes them the best person. Okay. I would be cautious about a requirement that they include somebody else, because they may not have that person on staff, couldn't recruit them in order to do this project, would be awkward to. Probably if the concern persists because of a prior relationship, that would be a reason to hire someone else in a similar but different vein to balance that for the perception issue that you articulated.
So we eliminate that by the vetting process and the selection process. We eliminate that.
Well,
On the front end.
That would be the hope that you could
that-
demonstrate, by demonstrating to yourselves.
Selection.
Hopefully you demonstrate to the public that notwithstanding a prior relationship, they're the best firm or person for the job.
Okay.
There are some firms that actually require their employees to sign a contract that they can't even work for the competitors. So I don't know if that would be an issue
I
here,
see.
but it could be. We don't get to just kind of decide who's going to win. We've spelled out in this bid exactly how we're going to score these bids, and notwithstanding how happy we are, if we're looking at a response and they clearly are the best response, we are obligated under the conditions of this evaluation section to award accordingly. And in fact, if we don't, it could be grounds for a protest.
Okay.
So, and what's interesting is awards, this award or this scoring and points provides us some ability to make a subjective decision. It's not like a bid where it's just a low price and it's objective and clear. So even this, what we're doing, I think is subjective. But we do have to follow these guidelines. And the amount of points and weight that we've said we're going to attribute to each response or category, that's what we have to do. And then we're going to end up with a winner.
Okay. Thank you.
We want them to be a winner.
And since I know
Let's hope. Let's hope. We're hopeful.
I know we're kind of getting close to the end of our time, but I was wondering if my fellow commissioners would think it might be useful to have a brief discussion about the time frame for us, what we could bring to the full commission in terms of our time frame for the next couple of weeks. It's my understanding in talking with Mr. Claypole that there were some dates potentially set aside for the full commission to do some review of these potential contractors, as well as the opportunity maybe to, if we wanted to actually open them, which I think there's a lot of merit to it, to physically open them in a public setting so that they can be presented in a live stream. Maybe I'll have Mr. Claypole talk about that.
Okay, so originally when we were looking at this document, we were thinking about the some dates that have been put in, the 15th being a time when we would receive them, and then the 18th being a time when we could award them. Now, talking with Carol, because it's gone back to DGS and they're looking at it, and now they're talking about possibly not having it till next week. I don't know what that's going to do to that time frame. So what we have to do is we have to decide whether we're going to have our meeting the 9th, 10th, or 11th, or some configuration there, or push it back. And my thought when I spoke originally with Commissioner DiGiulio was it made more sense, and I also, by the way, discussed this with Commissioners Blanco and Filkins-Weber, because they will be the chair and the vice chair of that meeting, that it made more sense to postpone the 9th, 10th, and 11th, and then push the dates back to the 17th, 18th, and 19th, which are Thursday, Friday, and Saturday, so that we could have the opportunity to publicly review these bids after we had put them online for the we can open them. They'll all be sealed, and then the idea was we would open them on the 15th, put them online, everybody could see them, we could publicly review them, publicly score them, and then announce the award. At this point, that time frame may be in jeopardy just based on the DGS's review. So tomorrow is our deadline for posting 14-day notice for the 9th, 10th, and 11th. And so I just need to see how that plays out. I hate to string you along like this, but our problem is not knowing when we'll get the review back from DGS. It may push us into having to have an early meeting beyond the 19th, maybe the 20th, 21st, 22nd. But it's imperative that once we get these bids in, we move as quickly as possible to that review and that scoring, because that's what keeps it on track.
I need to be clear about how the commission is going to be involved in the evaluation, and I'm not sure I am. Understand that the whole process is very confidential. From the time we start talking about the specifications, we're signing confidentiality statements. And the bids are confidential until we complete our score. After we complete our scoring, then they become public. The contractors can look at the bids, they can look at our scoring evaluation sheets.
And when you say we, who's the we you're referring to?
The evaluation team.
Yes, okay.
And again, the whole process is considered very confidential, and we should not be divulging any aspect of one bidder's response to the other or anybody outside of the group of evaluators. So my question is we received the bids. The few of us that have been working is the points and the scoring going to be accomplished, and then you're going to look at it before we issue an intent to award? Is that how the schedule works?
Well, and so this is actually, we're playing this out as we're talking about right here. I was under the impression that once we open the bids that they could be made public for a review. Can we write the contract subject to a public review?
Now, when you say public, do you mean the commission or everybody?
I mean posted online for everyone to see who bid and what their bid is.
No.
Okay.
No.
Huh?
I don't know, and I say that. You know, do I need to go back and read the code and find out if we could do that? Maybe. But
Right.
I say no based on my experience is that we want to make a determination of who we think is most qualified to meet our best interest. Now, if you're involved in that, but I don't know that we want the public involved in that. I mean, I don't know how the public is qualified to make a best interest about, I don't know. So it was not my thought at all that the public's going to have any bearing whatsoever in how we score these bids and the ultimate intent to award. Now, I would guess we could open that up to this whole committee and you can all sign evaluation sheets. But here's the other problem. I don't know how all of you are going to be involved in this, and we're going to be able to timely open these bids, score them, publish an intent to award, and then a 5-day protest period occurs. We're in the last week of March. So I'm not sure how I'm envisioning all of this group and how we're going to get together. It can be done because there are evaluation committees this big. But the larger we make this evaluation committee, I would propose. Do I get to propose?
Well, certainly. Suggest. Go ahead.
He's getting used to it.
Go ahead and suggest.
I would suggest we do the evaluation and we share it with you. And so you see what we've got. If you've got any concerns or any questions, then get back to us and we'll redraft or redo something before we post an intent to award.
Can I go back again? Who would be the individuals, that would be scoring them if it's not us, the commission?
Dan and Raul.
Well,
Who else?
actually, and we need to have a discussion about this, and clearly we need to come back to you tomorrow, and look at the code. We'd had a discussion early on among staff that just for transparency purposes, it didn't make a lot of sense for staff that had not been vetted to make these considerations. That it made more sense for the commission to do it, realizing that it makes for a long day. But let us get together and find out what the code says, and come back to you and propose, suggest a venue for this to occur in. But I do believe that it is very important that this commission is selecting the two. We're going to be selecting the two most important components of your consultants. And I think it's important that it be done by you in a place where it can be viewed and where the discussion can be heard.
This might be an appropriate time for comments from the public on this issue as well. Yes, Mr. Quinn.
Public, I don't know.
Yes, if I could, I just think I do reflect maybe a little bit of what you'll hear from the public. First of all, the Act says that you are supposed to establish protocols regarding your hiring of staff. Secondly, the Act says that all documents have to be public. Now, I realize that's a little different than elsewhere in state service. And I was in state service. I've gone through this process when I worked on that. I have one quick suggestion. Perhaps you might ask for a very fast opinion from the Attorney General's office as to whether you can go out public because of the fact that you're established not through the regular code, but you're established via an initiative that the purpose of the initiative was to have an entirely public process. I must say that I do hope that you can open the bids in public, that I can see them, the other people that are paranoid, as we all are, about this process. So I do hope that there's some way that you can figure out to make the process public.
Yes, Carol. And we have one other person from the public coming up.
Thank you, Mr. Chairman and members. I'm Trudy Schaefer, representing the League of Women Voters of California. And I would echo what Mr. Quinn has said to the extent you can possibly open the process up. I recognize that that does mean getting opinions and consulting the statute. But to the extent possible, I would hope that you would make it public. And I would also suggest that in these next day or two, that you make provision for getting input from the public who may not be here in Sacramento. I think you are likely to receive emails, and I hope you will make sure that those can be distributed to all of the members of the Commission so that you can hear from people who have had a little more time to think about the ramifications of this and who may know more about the possibilities and about the way the Act was constructed. And I certainly want to thank you for distributing the draft of the RFP at this point and hope that as the meeting goes on, you can think ahead and have as many of those sorts of documents available to us early. Thank you.
Thank you. Anyone else? Yes, sir.
Good morning. My name is Sam Walton, and I'm representing the NAACP. And I would echo the comments by the other two presenters. I know it's difficult. I mean, this is an unusual process, and I'm impressed with the fact that once the door is open and that the public is viewing all of it. And how we behave in public, I guess, is something that the public is going to see. How we've behaved historically behind the closed doors, the public is now going to see. And I think this transparency is absolutely important. And I do think if you open the bid publicly, you don't have to take any more. No one should be able to change their proposal after they've submitted it. So I don't know why the public can't also see whatever it is the evaluators are actually going to be going over. And I think having the process opening the bids in public is really a change in the way we've operated. And I think this initiative is bringing us all to a change in the way we've done business. Thank you.
Thank you very much. Are there any other comments? Yes, Carol.
I need to clarify. Absolutely, the bids, our scoring, our evaluation methods, all of that is public. It's a question of when. What occurs is if you've got an invitation for bid and you've got a requirement for XYZ and you're going to award based on low price, that's real easy. The bids are due at 2 o'clock. The public can be there. Everybody can see it. You open the bid, you put them on a board, and everybody knows there's a low price. And you can see, and then there's an opportunity for the public to look at every aspect of the bid response, of the evaluation sheets. All of that is public. That is true with this bid also. But the difference is, because we have requirements that are going to be scored, and we're going to have to dissect that information and then weigh how many points we give this bid versus that bid. There's no way when the bid is due that we're going to be able to open it and have any conclusion or result about the outcome of that scoring process. So therein is my dilemma about at what point. So in this process, what we do is once we finish that scoring and we're ready to make an intent to bid, we make all that information public. But you will have all that information. But it's not going to be computed at the time the bid's due because we've got to assess the input and assign scores and weights and come up with a final and highest point. And I don't see any problem with the commission being the evaluation commission. Absolutely. You can join in on that scoring. That, if all of us join in on that scoring, consider the time that that's going to take. And then if you consider that you open up that evaluation and scoring to the whole public, we will not award a contract by April 1. That's not possible.
Is it something where we could do a kind of a hybrid of what we've done in the past to some degree, where if we as a commission serve as the scoring, similar to other staff hires where we've been given their application material, we were given the parameters based on what they were asked, and in this case we'd have a clearly set out parameters with actual scored points associated, then we as commissioners would review all of those bids, put our scores, and then maybe as a hybrid we could come into the public similar as we were as we were presenting our findings for the replacement for Commissioner Quo. We could have something where it could be projected up to the public. They could see each one of our individual scores, or I'm not sure to what level. Maybe this is something for Mr. Claypool to work out, but I know if there was a hybrid from what we've done in the past and incorporating this and making it public still.
It's really time.
I think that we have a misconception. We're not inviting the public to participate in the scoring. We are inviting the public to witness the scoring. That's the first thing. So it's not going to be a what does everybody think about a 44 for this one. It is more of a this is the process in public, and then we would go through and make the award. But we need to come up with this process. It was originally, and I knew what Carol's just told you, that traditionally staff does this for you. But in this particular case, there have been comments, as you've just heard, that they would like to see the individuals, scored by the people who were put in these, onto the commission. Will it make for a long day? Yes. Do we need to find out what we can legally post and what we can't? Yes. But I don't see a way around it.
Well, we have no legal authority to keep this information from the public. So understand, absolutely, our scoring sheets, our weights, all of the bid submittals, all of that is public information. But again, on this type of bid where we've got evaluations to make and weights to make, that does not become public until we're finished with that scoring. Once we finish our scoring, we're going to have to come to a position where we've got an intent to bid. We've picked a supplier. The 5-day protest doesn't start until we've come to that conclusion. As it stands, the time frame is too short. So when we look at whatever we decide to do, you have to understand that it may mean that we can't award this contract by April 1. We just need to look very closely.
I think that if I could make another suggestion, I think we need to find out what's legally possible and come back to you with a suggestion for how we might do this in public, as you've heard the public wants.
That's pretty much where I am, and I think as we've heard from the public comments, we should make it as transparent as is possible and still get the job done, and with the time constraint that we're facing. And I think it's also a good observation if there's ways of altering the current, getting permission to alter the current law, we ought to look into that as well if it would expedite things for us.
We can't release this bid until we clarify how this is going to work.
Yeah, and that's why we'd like to hear pretty quick on that one.
Right.
Because it has to be spelled out in the bid.
Yeah.
And we'll work on that this afternoon.
Yeah. And given the comments from the, that were made by the public, I would just like to, I think I speak for the technical advisory group, we share that policy and that philosophy, but you also have to understand we're under the gun relative to get the job done, and so we're going to try to get as much out as we can within the confines and the rules that we're working with, and we'll do the best that we can to get the job done in time. And my colleagues like to comment? Cabino, did you want?
Yes, I agree with speakers that have argued for transparency. Certainly, that's why we're citizens, because we want to relate to all our brothers and sister citizens out there and try to make sure that not only that we are transparent, but I think this is an educational endeavor where the public gets to see how the commission is conducting its business, and I agree that there are rules that constrain public participation, rules regarding public comment being one of those, and that really we need to be deliberate and engaging the citizen, and I think this is a very democratic process.
Any other comments?
I just ditto that statement.
Is there anything else that Dan wants to talk about?
Dan, I think we've covered our agenda. Is there anything else you want to add as from the executive director's point of view?
I believe that our chief counsel wanted a motion on the conflicts policy. Yes, and if you're satisfied with it, or if we need to adjust it.
Want to make that motion?
Yeah, some grammatical.
It takes away our options for future editions, but okay.
I think there's an extra "and" in there.
On the last sentence for the conflicts policy, I would, just for clarity, delete the comma on the second to last line where after authorize.
And the word
And then-
next to it.
Authorize.
You selected the act and the regulations
and
authorize
authorize.
the commission.
See, well, I think what he's trying to capture in this one sentence is there's authorization, one, and two, the commission therefore will apply its conflict provisions with discretion, comma, while also assuring the impartiality of staff and consultants. I'm assuming that's the reading of it, but that's why the language is a bit.
I assumed it to be to take the comma off of authorize, to remove the and, the commission to apply its conflict provisions with discretion, comma, while also assuring the impartiality of staff and consultants. That's how I read that sentence to be.
That's fine too, as long as we're clear that there's authorization, and that I think it naturally follows that we will exercise our authority in doing so. I think he's trying to capture both authority and you will do it. But if we simply say authority, that will imply that we will engage in the process of.
Actually, I would argue that those are two independent clauses.
Okay, no, that's fine too. So.
Okay, so we need one change. If somebody will give it to us, we'll put it together.
How about it? Well, go ahead.
Well, I don't know. It depends on, again, actually, is it sufficient, do the other commissioners feel it's sufficient to simply say that we have the authority to do so, and there, by implication, we will therefore exercise that authority and exercise our discretion? Because if it's both, as it is, they're two separate ideas, then this is basically correct. It just needs to be cleaned up in terms of the punctuation.
I would I would move that we treat those as two independent actions.
Okay.
And that we would follow Mr. Anchetta's suggestion that we strike the comma after authorize, add a comma after discretion, and remove one of the periods after consult.
Okay.
You okay with that?
So, I mean, that is the intent of the language, yeah.
So you want to put that in the form of a motion?
I would make that motion.
Okay, is there a second?
Second.
Okay. Any further discussion? Any comment from the public? Okay, if not, then Peter.
I think it's.
If you read this sentence in its entirety, in order to permit a broad-based pool from which highly qualified applicants may be selected, the Act and regulation authorize the Commission to apply or will apply. I guess this question is directed at Commissioner Aguirre.
Yeah, I see that as two independent activities,
So the
separate activities, so I wouldn't strike the and I wouldn't change the will.
So would it be then to the Act and the regulations authorize, comma, and the Commission will apply, comma, its conflict provisions with discretion while also. Is that where the two commas go?
That's another way you can punctuate it, yeah. You can either take them both, take them out, or put two in.
That allows for that.
Okay, thank you.
All right, so,
I'll accept the punctuation amendment.
so
now
all in favor of that, say aye and raise your hand. Aye. Any opposed? Abstentions? So passed.
Comment on a comma?
Okay, let's call then, any comments from the public before we close? Oh, yeah, we have one up here.
and Dan.
No, okay. What?
Dan.
Dan,
Oh,
you're not the public, but you can speak to.
No, actually, we were working over some of these issues, but no, I have no further comments.
Okay, so let's bring this session of the...
Sorry, one more person in the audience.
Oh, excuse me, I didn't see your hand. You have to come up to the microphone.
Sorry, it's Aubrey Valentine with California Forward. I just wanted to double check. Will there be since the RFI wasn't available until the meeting, and we understand you've been working really, really hard to pull this all together very quickly, will there be some 24 hours or something for people who weren't able to be at this meeting to review it and provide comment to you?
Well,
I know it was discussed, but it was the folks that I talked to weren't sure what the response
Are you
was.
talking about an RFI for legal services?
For the technical assistance and line drawers and legal.
It's probably going to be an invitation for bid. It hasn't been published, so it's not available yet.
we made a draft available so that individuals could see it,
Right.
The statement of work.
and you can comment on the statement of work in it, because
I was
the other one isn't, because it won't be completed with DGS for
It's currently being processed.
currently being processed.
The
So
formal bid itself.
Okay.
And it will be published and released online at the Department of General Services website. It's contract advertising opportunities. All bids are published out there, so
I apologize for coming in at the end of this, but the material that you've been discussing at today's meeting.
it's just is the statement of work and statement of requirements that will be the primary
And is there an
input into the
opportunity to
bid.
comment on that?
yes, if you
Okay,
if you
perfect.
wish to submit comments on that, you can, and then we can take a look at them
And what's the
incorporate
time frame that suits you? When do you need comments by?
them. Preferably, it would be within the next 24 hours.
Okay, great. Super, thank you. Thank you.
Take one of these extras. Thank you very much.
Anyone else wanting to make a comment? All right, with that, then let's call this meeting to an end. Thank you all very much for your interest, and the public as well.